Terrific. Hello, everybody. This is Nina Olson from the Center for Taxpayer Rights, and this is our 10th in a series of tax chats on transforming tax administration. And we are going to look today at IRS collection policies and practices, and we have a really great group of guests today. Jeff Wilson from the IRS Taxpayer Advocate Service, and he is the Senior Research Advisor to the National Taxpayer Advocate, and anyone who has worked with Jeff over the years holds him in the highest esteem. He is just absolutely wonderful, and I have learned so much from him over the years. We have Les Book from Villanova Law School, and those of you know he is the author of the treatise, the Michael Saltzman treatise on IRS practice and procedure, and also one of the co-founders of Procedurally Taxing, the blog on tax procedure and administration, and Mary Gillum, who is with the Tennessee Taxpayer Project, the Low-Income Taxpayer Clinic, for the, don't know whether I'm going to say it right, Legal Services for East Tennessee and the Cumberlands. Did I get it right or close or kind of?
That is correct. And it also basically includes 91 of the 95 counties in Tennessee. So
there you go. So it's basically all of Tennessee except for some little places or not so little places. So I thought I would just start framing our conversation. You know, I have always said that whereas exam and audits get a tremendous amount of attention from the taxpayer's perspective, in many ways, audits are abstract because it's not until the IRS actually starts collecting tax, you know, reaching into your bank account, or trying to take your property or asking you to set up a payment plan, that you're actually experiencing the impact of the audit. And that is really for taxpayers where the greatest impact is felt on a day-to-day basis. And what we have seen over the years, and certainly that's been a focus in when I was the National Taxpayer Advocate and now afterwards, was the IRS moving more to automation, moving to very few outbound calls and collection practice, and basically using notices and massive call centers and automation to do the collection of tax. And that's been moving into the area of setting up installment agreements with the online installment agreement, and then also using, and this is Congress's doing, introducing the role of private collection agencies. And as National Taxpayer Advocate, you know, I did a fair amount of work on those in our annual reports to Congress, but also through the research function, which is why I really wanted Jeff to show up. And I will say that what I saw in the IRS research, in the IRS functions in terms of collection, was what I would call a singular lack of curiosity about why taxpayers weren't able to pay, and how to address those payments. The focus was on getting that money, and you see that in the IRM, you see in the Internal Revenue Manual, you see that reflected in all of the IRS procedures, and you see it in the call scripts where the first question is, can you pay the debt in full? Can you pay it over time? And then only much later, if at all, do you get to, can you actually afford to pay this debt entirely? When I first came into the IRS, the collection people were talking about the 3 C's, focusing on cause, cure, and compliance. That was in the Internal Revenue Manual. Identify the cause for the non-compliance with collection. Then think about how you can correct that issue, that non-compliance, cure it. What were the collection alternatives that you would use? And then going to thinking about how to keep that taxpayer in compliance going forward. And those 3 things were supposed to be holistic. So you didn't put the taxpayer in a payment plan that would cause them to default or actually get a balance due in future years. That disappeared from the IRM somewhere during my term as National Taxpayer Advocate. And certainly you saw that focus disappearing in the collection initiatives. The final thing I'll say about this is that the IRS Strategic Operating Plan has identified 2 initiatives dealing with collection. One is Strategic Operating Plan Initiative 2.5, which is titled Offer Proactive Debt Resolution. And then the other is 2.7, Use Improved Data and Analytics to Tailor Timely Collection Contacts. Now, I do suggest that you watch, if you didn't watch it before, go back, and when we've posted it online, you can watch the Tax Chat number 9, where Michael Halsworth from the Behavioral Insight team talks about some of the work his unit has done on generating collection payments from taxpayers by using different notices and language in different notices. And some of what we're going to talk about today is IRS notices and the communications, but a whole bunch of other stuff. So back in 2009, the Taxpayer Advocate Service published pretty much its first collection research study, which was looking at the subsequent compliance behavior of delinquent taxpayers. And that study set up our work for the rest, at least of my term as National Taxpayer Advocate in the research field. And now there is ongoing work. So with that, I'm going to turn it over to Jeff, and I will do my screen share so you all can see his slides. And Jeff, just let me know when you want me to move through the slides so that
Thank you, Nina. And good morning or good afternoon, everyone, depending on where you are. I just thought I would start out by highlighting a few of the statistics from some of the Taxpayer Advocate Service research studies over the last few years that look at collection outcomes, to sort of provide, I guess, a framework for what we're going to talk about. So if you look at the next slide, back in 2015, we did a study on the individual collectability curve. In other words, looking at how much money comes in the first year and the second year. Private industry sometimes looks at this in 3-month intervals. And what we found out was that dollars collected on taxpayer delinquent accounts, which is basically a balance due that's still owing after the IRS sends a series of 3 to 4 notices, that the dollars collected on those liabilities decreased by more than 50% after the first year that the delinquency arose, compared to what was collected in the second year. So in the second year, we're only going to collect less than half of what we did in the first year. And then in that third year, collections decrease by about 1/3 more from the amount that was collected in the second year. And so it's also not just collections are not going down because the balance is being paid on, but dollars collected as a percent of the balance remaining as the years progress also continue to decrease. And so it kind of illustrates the point that the IRS has to get to liabilities early and address those liabilities, or they're unlikely to really make any significant collections on those. Could you go to the next slide, please? And we see then that about 3/4 of the taxpayer delinquent account assessments have balances of $5,000 or less. So most of them are small liabilities that could be addressed quickly. However, the ones that have those larger balances above $5,000, they account for a lot more of the money that's owing. When you look at the type of assessment, and Nina started out talking about audit assessments, we found out that the IRS collects much more from self-reported taxes than from audit assessments, which obviously audits have to occur, as part of good tax administration to make sure that taxpayers are complying with the law, but probably the IRS doesn't always look at collectability in terms of conducting audits. And then lastly, substitute for return assessments, which is where the IRS, you haven't filed a return and the IRS is going to estimate what you owe based on the information documents that they have and give you no benefit really in terms of filing status or dependence, and file a return with you. And we find out that about 50% of those assessments are actually abated. And then just to take this further, and this is Nina was talking at the beginning about addressing cause and then cure and then subsequent compliance. We did a study in 2009 on much older data, on 2002 data, and we're looking at balances that were occurring after the economic downturn then. And what we found out was that the IRS doesn't do a real good job at preventing future non-compliance. So that taxpayers placed in the queue, we see that over half have a subsequent liability, a balance due, and that increases to over 3/4 or 75% if you look at they had a subsequent liability or they didn't file a tax return. And so those cases that the IRS places in the queue are those ones that the IRS really doesn't have enough resources to work right now, and so they go in this waiting area. And so these are the people that really see a delayed reaction from the IRS in terms of addressing their collection issue. Taxpayers that the IRS reports is currently not collectible because of a financial hardship, they fare a little better, but it's still 45% have a subsequent liability, and almost 60% have that liability or an unfiled return. And I'll just quickly look at two more types of cases on the next slide. Taxpayers whose liabilities are assigned to either the automated collection system or the collection field function, where a revenue officer looks at the case. Still over 50% of those have a subsequent liability, and 74%, nearly 3/4, have a subsequent liability or an unfiled return. And then lastly, we see that there are also high rates of subsequent non-compliance with taxpayers who had a discharge of indebtedness or a bankruptcy, with more than 60% having a subsequent liability or unfiled return. So, we've seen that the IRS needs to get to these liabilities quickly, and we also see that we have a large recidivism, a rate of recidivism when taxpayers have a liability. And I should point out that the way this study was designed, we were looking at taxpayers that had new delinquent liabilities in 2002. So these weren't habitual offenders, but these were new folks. And maybe I should use the word offender, but new folks that had liabilities that had not had prior problems. So then I'll just finish up with a few slides about offers and compromise, because that is one way to resolve a liability more quickly when the taxpayer doesn't have an ability to pay all of the liability. And we find out that when we look at that subsequent compliance, that taxpayers with accepted offers have much better subsequent compliance than those taxpayers whose offers are rejected. And you can see there on the slide that it's 16% difference, that 58% of taxpayers with accepted offers and compromise had no subsequent late return liability, compared to only 42% for those whose offers were rejected. And we see something similar when we look at subsequent balances due, where 72% of taxpayers with accepted offers had no subsequent liability compared to only 52%, so 20% higher compared to those taxpayers whose offers were rejected. And of course, the terms of an offer in compromise with the IRS requires that the taxpayer does have to remain in compliance for 5 years for the offer to be completed. But I think there's decent evidence that it gets the taxpayers in the habit of being compliant, and that compliance continues.
Mm-hmm.
And so the very last thing that I will talk about is a new study that the IRS is doing in conjunction with TAS. TAS is working with a small business and self-employed operating division to try to encourage taxpayers to file offers where it doesn't appear that they can pay. And so relatively few taxpayers file offers in compromise. I put here on the slide less than 1%. I was looking this morning at the numbers from last fiscal year, and it's really barely over 0.1%. So we're doing this pilot where we're sending out a one-page letter to taxpayers whose 2022 refund was offset, but there's still a balance due that remains. We're piloting it. We're testing it with 2,500 taxpayers. And then we have a comparable control group of another 5,000 taxpayers, which is kind of typical to have a control group that's about twice as large as the test group. And we're looking to see if we can encourage taxpayers to file offers in compromise. If we look at the next slide, talk about the additional requirements to be in the pilot. These taxpayers were those who defaulted on an installment agreement in fiscal year 21 or 22 that hasn't been reinstated. They're current on filing their recent income tax returns. They have no systemic indication. In other words, the IRS doesn't know that they have any real estate. They recently have received the earned income tax credit, so they're relatively lower income taxpayers. And to the best that the IRS can tell, their income does not exceed their allowable expenses. So it looks like they really don't have any wherewithal to pay, and the fact that they have a prior installment agreement supports that. So we think that these are people who are going to be good candidates for an offer. Over the last several years, the number of offers in compromise being submitted have declined, and we're hoping to look at a way to reverse that and get more viable offers that are both a benefit to the IRS because they're going to get more money than they would probably collect if it were to continue throughout the 10-year collection statute, and be of less burden to the taxpayer. And then I think the next slide, which is really I guess it's the next to the last one, but this has the message that appears on the letter. So it's telling them that we recently offset their refund, and we had sent them a notice and tell them that. And there might be a way that they can prevent future overpayments. And so we're hoping that by the fact that they lost a refund, they will be incentivized to want to apply for an offer so this doesn't happen again. And it tells them that they can settle it for less than what they owe. They can settle their liability. And then the next slide, which I promise is the last one, just a few things about the pilot letter. It has an IRS contact number on it. IRS notices are less and less likely now to include a contact number, which can be disconcerting. But it also has a website address and a quick response code so that the taxpayer can use their cell phone or their home computer to access the site to get more information. And it also lists resources that they can call for assistance, including the low income tax clinics. So that's just kind of an overview of some statistics and trying to provide some data that might assist in this discussion.
Thank you, Jeff. That's really like that. That really sets up the whole situation. That first of all, you need to address debts early, or else the 10-year collection statute just means very little. Secondly, that you need to design your collection initiatives with that last C in mind, compliance going forward. And I think that SBSE task study is going to be very interesting and very promising. And I like how it's associated with the sense of loss, because there's a lot of behavioral research and psychological research that shows that people actually value, or that the idea of a loss actually has greater impact on one's behavior than gaining something. Losing something that you have drives behavior more than taking an action to gain something. And I think that's very interesting how you set it up. I think it also sets up, before we shift to Les to talk about collection due process and collection alternatives, some work that we had done, and you may want to weigh in on this a bit, Jeff, is as we looked at all this data and saw how people were entering into installment agreements through automated processes, if you did an analysis of their income versus the IRS's allowable expense standards, they didn't have the ability to pay their basic living expenses. And in this study that you've talked about with SBSE, it looks like you're beginning to insert that algorithm that TAS had created for our studies of looking at the taxpayer's latest filed return or their information return data and trying to create a sense of, are you at risk of economic hardship? Because it looks like your income that we've got records of internally look like it's less than the IRS's allowable living expenses. And therefore we shouldn't be moving forward collecting against you if you cannot, or even putting you in an installment agreement if you cannot afford to pay your basic living expenses. TAS had proposed several things. For example, we'd proposed that the IRS create an indicator on the taxpayer's account where every single debt, once it got to the TDA status, the tax delinquency account status, the indicator would go on the taxpayer's account if the algorithm indicated that they were at risk of economic hardship. And that way, if the taxpayer called an ACS assister or an RO got assigned, a revenue officer got assigned that case, they could look at the taxpayer's account. It would come up saying, this is a taxpayer at risk of economic hardship. You need to ask some additional questions. So rather than saying you need to pay this in full, you go immediately to, let's talk a little bit about your income and expenses to see whether you can afford to pay this. Same thing we've proposed for the online installment thing, that the economic hardship indicator could actually, if the taxpayer put in their social and then they're trying to do an online installment agreement, it can pop up that the economic hardship indicator can pop up and cause a screen to come which would gather more information, so you could actually make a determination right then and there that taxpayer is in economic hardship, currently not collectible hardship, then shunt them to offers and compromise rather than doing an installment agreement. So what's your sense? When I left in 2019, I had issued a taxpayer advocate directive, and the IRS's response was, no, we're not doing this. So what's your sense now, given what the language is in the strategic operating plan, where the IRS is?
I don't know that I'm sure where the IRS is. They still have their concerns. We did a study a couple of years ago, and it does show that the algorithm is over 80% accurate. I think the IRS would like that to be a little higher. And of course, there are always fluctuations, people move, and so their allowable expenses are different. But the fact that SDSE has agreed to use this as a factor in this pilot gives me some hope that, eventually it will be more widely adopted into other IRS collection practices.
Yeah, I think that's really, that I think what they never really caught on to, I kept saying, this is not a determination that the taxpayer is in economic hardship. This is an indicator that prompts you to get the information that you need in order to make that determination. And the IRS always leapt over that statement. They just went to, we can't make a determination based on this algorithm. It's like 80% is really accurate. You've got fraud detection filters that are 9% accurate, and you're using them. So, come on, guys, but it was difficult, which just, that's the mentality that you're dealing with. And I'm really pleased about this study that you've got. We do have a couple of questions. I just want to say, the ABA in 2021 submitted comments saying the IRS should use the OIC pre-qualifier as a model for developing an online OIC application. I would have concerns about that. I think it's not sophisticated enough. And then someone else asked, why would I file an OIC if the taxpayer is CNC and there is no indicator that their financial situation will change? Why not just let the statute run instead of extending it with an OIC? I'm going to let Mary answer that one, but Jeff, do you want to talk about, do you have any knowledge about the IRS looking to an online OIC application?
I do not have. I know they have the OIC pre-qualifier. I guess my initial sense is that I think these are very complicated, agreements that are entered into, and it would be difficult to do it electronically. It would be probably difficult for both the taxpayer and the IRS, and it's probably something that does need a conversation, not just done electronically, but that's my opinion.
Yeah. Okay, maybe we'll hold off the OIC, or Mary, do you want to address the question about why you would file an OIC where the taxpayer's in CNC?
Absolutely, because we, through the low-income taxpayer clinic, that's a big conversation we have with taxpayers when they're coming in and there's no liability defense, not a viable one, and collection alternative is something that we're considering pursuing. The first reason I would give as to why you'd want to pursue an OIC just versus taking CNC, since it's a simpler process to do a short financial statement and talk to a collections representative and get in CNC versus an offer, which is a more long drawn out process with a lot of document collection. One reason there's a huge benefit is closure. Peace of mind. Many of my clients through our low-income taxpayer clinic face a lot of mental health issues. And even our clients that don't, they just really want closure on this IRS issue, and so that they can have a fresh start towards future compliance. So that is one big reason, is just getting that closure. When I mentioned to clients that there's no closure with CNC and the statute, they're going to have to wait another 24 months or maybe 5 years, that's just something that's not palatable to them. So again, it really depends on how long though you have left on the collection statute. Now, you probably you would not want to look at an offer and compromise if you have 12 months left on the collection statute, because one, like you pointed out, it does extend the collection statute. And it's a lot of work when something may be going away on its own in 12 months or less anyway. But most of my clients don't have a short period left on the collection statute. So closure and peace of mind is a preference. Another reason is you want to get your future tax refunds. So I have a lot of earned income tax credit recipients who, if they stay in CNC, then their refunds are going to be offset. But if they get an offer and compromise and comply with that payment requirement, then they can start getting their tax refunds. And that's probably one of the biggest reasons for my client population who qualifies for the earned income tax credit, especially those that have qualifying children in the home. And then I have a lot of elderly clients that really prefer the OIC because they just can't deal with getting annual reminder letters from the IRS of their balance, even if they're currently not collectible in the letter and the government's not going to take any action. just getting that letter causes such an intense amount of stress with a lot of my clients, but especially my elderly population. So that is 3 reasons I generally look at an offer in compromise and try to persuade the taxpayer to focus on that collection alternative rather than looking at currently not collectible. But there's always exceptions for, and like I said, with currently not collectible, it may be desirable if there's a short period left on the collection statute.
That's great, Nancy. That's really helpful. Well, now, Les, do you want to pick up and talk about collection due process and share your slides?
Sure. Thanks so much, and it's really a pleasure to be here. Thanks for organizing this, and I, in talking, in listening to Mary and Jeff and Nina's introduction, it kind of struck home to me that one of the things that comes up in this conversation is the taxpayers have defined interest in the collection process, and what I wanted to do today in today's talk is really kind of situate our discussion with a little bit of history and context. Because frankly, the modern tax collection system is actually pretty young, at least as compared to the process for reviewing IRS determinations with respect to questions about the amount or existence of a liability or a refund. And unlike questions in cases involving questions about liability, where there had been really a well-defined procedural landscape and a body of law that addresses substantive issues. Back when I started in a tax clinic in 1997, I was really surprised to see that taxpayer rights in the collection process were pretty ill-defined and essentially subject to almost unfettered IRS discretion. You want an offer in compromise? Well, that depended not only on the circumstances of the taxpayer, but at times, arbitrary factors such as who is reviewing the request, and at times of perception that some taxpayers just didn't deserve relief from enforced collections due to the nature of their liability. And things changed dramatically in 1998, and within a year of when I started in the clinic, with RRA 98 and its CDP provisions really changed the relationship between the IRS and taxpayers in the collection process. Right, so CDP requires the IRS to provide taxpayers additional notice following assessment and provides taxpayers with administrative and judicial opportunities to challenge the IRS post-assessment determinations, including a very limited chance, but a chance nonetheless to review the amount of the existence of a liability. And I'll just talk briefly about a little bit more about CDP to situate us without going into all the details. So in CDP, the rights arise after the IRS formally issues an intent to levy or immediately following the filing of notice of lien. And when a taxpayer timely responds and requests a hearing, most collection actions are stayed, and it pushes on appeals an obligation to ensure that the IRS followed its rules leading to the assessment, allows a taxpayer to raise a request for relief in joint and several liability, or to request a collection alternative like an offer in compromise or an installment agreement. And if the taxpayer has not received a statutory notice of deficiency for taxes subject to deficiency procedures, or has otherwise not had an opportunity to dispute the liability, CDP also gives taxpayers the right to re-examine liability determinations at that stage. And it also triggers an independent obligation for appeals to consider whether any proposed collection action balances the need for the government's interest in efficiently collecting taxes with the legitimate concern that taxpayers have that collection action be no more intrusive than necessary. And I'll come back to that. And the statute itself reflects a remarkable and I would say even revolutionary change in tax administrations. Right, prior to CDP, as the slide kind of indicates, most IRS decisions with respect to administrative collection powers were not subject to judicial review. And in addition, CDP reflected one of the first times that Congress explicitly recognized that there are legitimate taxpayer interests in the collection process. And sure, collecting taxes is the lifeblood of government, but, and I'm paraphrasing Nina here, with CDP, the IRS now had to formally consider the interests of the folks who have the blood. And when I started the clinic, the work I was doing on collection cases made me want to take even a step further back and think about how CDP related to the ways that individuals' rights are generally protected against the erroneous exercise of government agency power. And the two most traditional means of protecting against arbitrary or erroneous federal agency actions are found in the Constitution and in the Administrative Procedure Act. So constitutional protections and organic statutory protections in terms of the APA. And the Fifth Amendment's procedural due process formally recognizes that when there is a protected interest like privacy or property, those interests, individuals are entitled to notice and generally entitled to some kind of hearing prior to the deprivation of those interests. And the APA provided a loose body of protections from agency determinations that provides a presumption that final agency actions are subject to a limited type of judicial review, again, to try to provide protections against erroneous agency actions. Well, for a whole host of reasons, tax collection has long sat outside the mainstream of procedural due process and APA jurisprudence. And what I mean by that is that courts have not found that constitutional procedural due process does much in terms of providing protection following assessment. And for that matter, it does really little in terms of pre-assessment protection too, but that really is a story for a different day. And in collection cases, the absence of any defined path for taxpayers to access courts, combined with the Anti-Injunction Act and the Declaratory Judgment Act, long had meant that taxpayers who had problems with IRS collection decisions were really not able to get courts to provide oversight or have a check for arbitrary IRS actions. Now, I overstate the case a bit because the code has and continues to provide some procedural protections if the IRS makes mistakes in the collection process. There is a third-party right to bring a claim for wrongful levy. There is also a limited right for taxpayers to bring an action for damages if the government IRS employee acts negligently, recklessly, or intentionally and disregards the code or regulations in the context of collection actions. But those are pretty limited. So in 1998, Congress provided a chance for taxpayers to step in and get court review. And again, I kind of laid out the differences in the prior slide. So how does CDP nudge the IRS and tax collection into kind of the mainstream in terms of what individuals were entitled to with respect to APA or constitutional protection? First, it provides an opportunity for some limited type of judicial review in the administrative collection process, right? And in the and you can go back a slide still, Lena. It's back one. Yep. In the pre-RRA 98 regime, there was almost no opportunity for courts to consider IRS actions, and but now the standard of review in collection cases draws heavily from the standard of review in the Administrative Procedure Act. In a manner similar to that abuse of discretion review in the APA in the context of informal agency adjudications outside tax. So in CDP cases now, right, the tax court has held that if appeals has abused its discretion or there's been a change in circumstances, it has the power to remand proceedings back to appeals, and the court retains jurisdiction to review a supplemental appeals determination. While the tax court takes the position that its remand power is not grounded in the APA, tax court review of collection matters now in CDP cases is similar to judicial review in that it that applies in most cases involving court review of agency adjudications. And that comes up in what is an ad law discussion or context, as was known as the ordinary remand rule. And I've listed in this slide the kinds of questions that courts ask when they have the right to consider agency actions on an abuse of discretion standard. And it varies slightly by circuit, but this is kind of the general context. You see, it's not quite a de novo review, and it's not as if the court is substituting its judgment, but it does provide an opportunity for the court to consider whether the agency has kind of gone off track. And again, it doesn't mean the court substitutes a judgment for the IRS and play the role as a second tax administrator, but as non-tax administrative law scholars have long argued, unfettered discretion can lead to the tendency for agencies to overlook the perspective of the non-governmental actor who's before that agency And it also provides having some type of limited review provides an opportunity to have a safety valve and correct for sloppy agency practices. So next slide, please. And there are a lot of cases that over the course of the last 2 decades plus that have considered what the court's role in the context of CDP cases when the IRS has gone astray. And in a recent blog post by Keith Fogg discusses a case, Whitaker versus Commissioner, where the tax court remanded a case when the taxpayer and appeals had a very different view on the eligibility for an offer in compromise that was at issue in a CDP case. The case concerns eligibility for an OIC for taxpayers who are close to retirement, and at a time, right when the pandemic had hit, and the taxpayer's ability to earn income was severely, compromised. I won't get too deep into the nitty-gritty of the case, but in a nutshell, the parties differed on a bunch of things, including the valuation on the house, the ability to refinance a mortgage, and it led to a difference in view in terms of what the taxpayer's reasonable collection potential was. Long story short, the IRS's appeals' notice of determination was pretty deficient in explaining why the settlement officer sustained the rejection, and the tax court remanded the case back to appeals. Now, the taxpayer did not at court get precisely what they asked for, meaning I'm sure they would have wanted an accepted offer at that stage, but the opinion did provide some assurance that on remand, appeals would take into more seriously the legitimate interests and arguments that the Whitakers had made or had tried to make below. And this is precisely the benefit in mind that Congress had when they provided for abuse of discretion review as the norm, consistent with most other agency informal adjudications. And next slide, please. I go into this a lot more detail in an article that came out just recently in the Pittsburgh Tax Review. Is a 25th anniversary retrospective on RRA 98. And the article, again, tries to really situate CDP with respect to some of the scholarship and thinking outside tax. And so there's a recent article from Professors Chris Walker and James Saywell, who in a 2021 George Washington Law Review article called Remand and Dialogue in Administrative Law, discuss the merits of abuse of discretion backstopped by remand, similar to what the tax court did in the Whitaker case that was in the blog that Keith wrote a few months ago. Walker and Saywell acknowledge claims that some who criticize abuse of discretion as too differential to agency action. After all, that some of the critics argue, shouldn't the court just decide the matter and have it be done with? And Walker and Saywell disagree, noting that by issuing a written opinion and remanding the matter back to the agency, courts can have a broader impact on agencies than just by de novo review, especially when there are high volume agency adjudications with many private parties failing to exercise their judicial review rights. And I'll come back to that in CDP in a minute. And the scholarship kind of continues along this path by talking about the role that written opinions can play in creating a dialogue between the judicial branch or courts and agencies. And this dialogue can even reach the agencies, can reach Congress and other actors to hopefully have an effect and an impact on an improving agency process. And the scholarship identifies a number of tools that courts have used to facilitate that dialogue, including ensuring that courts retain jurisdiction, proposing hypothetical solutions for the agency to consider, which at times, in fact, the tax court has employed when they've remanded cases back to the IRS to appeals in CDP cases. So while some who have criticized CDP for its imposing costs in the form of agency resources and providing an unilateral right for taxpayers to effectively pause collection, CDP really provides the oversight that taxpayers need and encourages a tax system that is more fair and just. It allows for the IRS for a meaningful way to appeal an IRS decision in an independent form. It provides a chance to challenge the IRS position and be heard. In other words, it provides a tax system or promotes a tax system that is more in accord with taxpayer rights. So are there things that that could help CDP do even more to promote rights? Maybe so, and I suspect that Nina and Mary and others will have thoughts when they talk about some specific cases, and I know Mary has some thoughts on this. But I do think just a couple of thoughts in terms of that, what could improve the process. And it relates, one thought relates to some of the prior tax chats that we've discussed, and something as well that Jeff discussed in his presentation, concerning communication. Right, there should be a real emphasis on improving communication with taxpayers in the collection process. Next slide, please. I note, and this slide kind of points the incredibly low take-up on requests for hearings and petitions following determinations that give rise to taxpayer CDP rights. And this slide comes from the most recent, or the 2021 annual report to Congress, where the Taxpayer Advocate Service, laid out how relatively infrequently it is for taxpayers to actually petition to file a request for a CDP hearing following a notice of intent to levy or the filing of a notice of tax lien. And I might also add a related issue and problem concerns when in the rare cases when taxpayers petition a matter to tax court, when the IRS files a request for summary judgment, a motion for summary judgment, there is oftentimes an inability for taxpayers, or an infrequent occasion for taxpayers, to respond to those requests for dispositive motions. So there is this sense that taxpayers perhaps are not able to fully understand or take advantage of the significant rights that Congress has provided. And I think future one area where I think future emphasis should be provided or turned to is how could this process be improved? How could the communication and correspondence be improved? What affirmative role should appeals play, or even counsel play in cases in court, to promote taxpayers and being able to respond adequately? Secondly, and next slide, please, I'm concerned at times that tax court and appeals take a dim view of the statutory requirement that the IRS is supposed to balance the need for the efficient collection of taxes with the notion that collection action should be no more intrusive than necessary. And this is related at times to, I think, an overly deferential attitude towards IRS decisions that it makes in collection. I talk about this in a blog post last week, which is on the slide, involving the case of Segerman versus Commissioner. And again, this case involves the IRS filing a notice of federal tax lien, and the taxpayer requesting that the IRS withdraw the lien based on claims that the lien filing harmed their ability to pay and contributed to forced liquidation of retirement accounts. The opinion itself is pretty brief, and the taxpayer, from what I can tell, did not sufficiently make the case as to why the IRS lien filing harmed his ability to continue making payments or meeting necessary expenses. Yet in the opinion, there was little discussion as to why the lien was necessary, and no discussion at all as to how the action might harm the taxpayer. And the assessment itself is from restitution in a criminal case. And in bankruptcy, there was non-dischargeability of restitution obligations. What was the government achieving in this case by following the lien? And from what I hear from my friends in practice at appeals, it seems when appeals issue CDP determinations, there is almost a pro forma statement that appeals has balanced the government's interest with the taxpayer's interest, without taking the time to connect the taxpayer's circumstances to the government's interest in the particular case at hand. And I think that leaves taxpayers in the dark. And what CDP does is it opens the door to the court stepping in and putting some more teeth, some real teeth, into Congress's explicit statement that the IRS is supposed to really consider the taxpayer's interest in addition to the government's interest in collection. And balancing is hard, and at times it may require the IRS or appeals to dig a bit. And as Nina said, that sometimes reflects, with the current practice, may reflect a lack of curiosity. And CDP is really a statutory or Congress's express statement that appeals needs to be curious and needs to dig a bit, especially in my opinion, when taxpayer is unrepresented. And collection determinations should not be subject to boilerplate And what CDP does is it really takes a step back and says, well, let's think more clearly and in a defined way about what the taxpayer interest might be. So with that, I'll stop, and I suspect Mary has some more particulars to say about how this plays out in some of the cases that she sees as well.
Yeah, you know, I think Mary is going to really have something to say. I think what's really important here, and I just want to put this in the context of the Taxpayer Bill of Rights before I hand it over to Mary, is that when I was negotiating and my staff were negotiating with the IRS about the descriptions for the 10 rights that were going to show up in the Bill of Rights, and this was in the summer of 2014 when the IRS adopted the Bill of Rights before it was codified. And we were negotiating the language of publication 1. Under the right to privacy, I had picked the language out of the CDP statute about no more intrusive than necessary to say that the taxpayers right to expect that IRS actions with respect to any enforcement activity, not just collection, would be no more intrusive than necessary. And I received back from the IRS team that was working this, which had representatives of counsel and everybody else on it, a red line version that struck out the language no more intrusive than necessary. So I had to go back to them and say, well, you might want to take that up with Congress because they've already codified that language. And to this day, that language is in the official description of right to privacy, although I personally am watching it like a hawk to make sure it doesn't disappear. You know, I think that just shows how uncomfortable the IRS is with this concept that yes, it has all these powers, but it has to consider the taxpayer's specific facts and circumstances. So Mary, I'll turn it over to you for your comments on this.
Thank you, Nina, Les, and taking into account with all the previous comments that have been said, I want to start before I go into utilizing some of the examples and observations I have. I want to go back to something Les said, and was talking about remands and how those remands, there's been developments in a body of case law with that dialogue with the court in those remands. I know when I first started practicing in this area back in 2000, it was very limited a lot of times when you could convince a court to remand a case back to appeals to look at something. It seems like things have really drastically changed over the years, and that body of law has grown. For example, now the courts, which I think is an appropriate position because things happen, and if you're going to look at collection through the lens or the eyes of a taxpayer, which is what I really would like to see IRS functions do, especially appeals and collection, you have to look at the things that taxpayers experience in their lives, low-income taxpayers especially. And so the courts have looked at that, and the courts have said, now, hey, you know, we can remand back when there's a change in circumstances after the CDP notice of determination, which is really important. The Churchill versus Commissioner case, which has been out a while, I think since 2011, Judge Holmes engaged in some helpful discussion about what would constitute a change in circumstances. And some examples that are noted there is a change in family status. There's a change in family status that's going to impact financials. So even if a IRS appeals officer or IRS appeals settlement officer determined that the taxpayer didn't qualify for collection alternative, after the notice of determination is issued, if there's a change in circumstances, maybe that taxpayer would qualify for collection alternative. So the court has found it appropriate to remand those cases back to IRS appeals when there has been a change in circumstances that could affect the validity of the agency decision. So that has been a very helpful, I think, some teeth that the court is putting into the CDP right of appeal. Another thing is I've seen in Hoyle versus Commissioner when the record wasn't fully developed. This is a 2008 case. The court has sent this back on remand to IRS appeals to look and fully develop the record so they can make a good determination as to whether your rejection of a collection alternative is an abuse of discretion. So that has come from some of the court's consideration of these cases. I also see mentioned in Martin versus Commissioner and in the Churchill case again, if the remand would just be necessary or productive to getting this resolved, which is really the goal here with CDP, is trying to get these tax liabilities resolved And looking at this balancing test, the court has said, hey, if it would be productive to send this back to appeals, we can do so. And the law has changed. That should be, that's something that you think is pretty evident. If the law's changed, that it would be something you want to send back on remand. But the IRS doesn't always look at it that way. And of course, when the appeals officer abuses their discretion. So there's been, I think, a lot of developments in case law where the courts had this dialogue with IRS and setting up what they want to see happen and what should be happening based upon the statutory language in a collection due process hearing. So going back to looking at as well how the IRS should, like if the IRS is focusing on collecting revenue, but they need to look at simultaneously protecting taxpayer rights, as Nina noted in for the development of the Taxpayer Bill of Rights. Some things that the IRS, I've seen in our utilization of the low-income taxpayer grant to help low-income taxpayers is really the IRS often fails to capitalize on collection alternatives. And I'll give you an example. Most of our clients qualify for nominal offer and compromise payments and maybe $10 or $25 to resolve a $20,000 or $30,000 tax liability. Well, you might ask, how is that beneficial to the government for the government to do that? Well, when the government does that through an offer, there's that requirement the taxpayer be compliant. You have to maintain compliance for the next 5 years. You have to file on time. You have to pay on time, or that entire offer can be defaulted and the taxpayer will go back to owing that substantial tax liability that was resolved through that offer and compromise. So it is beneficial even if the government's only collecting a settlement payment of $10 or $25. They're also getting something out of that, which you may not see initially as a monetary benefit, by getting that taxpayer to comply, to file the returns, which might be the, go back to the numbers I think you mentioned, Jeff. I think there was a 72% or 20% overall, I think, improvement from taxpayers who had offers rejected versus taxpayers who had offers accepted who did not have a future tax liability. I saw that like 52% to 72%. So the 72% being taxpayers who I think avoided future tax liabilities when they had an offer accepted versus the 52% that avoided them without having the offer accepted, maybe rejected. So there's a demonstration of the benefit in those numbers. But taxpayers also with larger offer amounts seem to have a lot more problems, I think, within taxpayers who have nominal amounts, because I think it's easier for the offer and compromise examiner, for example, in an offer and compromise situation, to say, oh, this taxpayer has a zero reasonable collection potential, so we'll accept their $10 or $25 offer. But we have taxpayers who do have assets sometimes and do have a reasonable collection potential that is greater than zero. And we find ourselves submitting offers in compromise of things in the nature of maybe, say, $36,000 or $5,000. I think back to a case where we submitted an offer of $5,000. And the taxpayer didn't have that $5,000 cash, but the local church had helped that taxpayer's small community where they take care of their own, and they had benefit singings and raised money and given this taxpayer $5,000 that they had offered the IRS in a collection due process hearing with an IRS appeals officer that offered $5,000 to settle their tax liability of a little over $50,000. The taxpayer's only asset was a mobile home that had equity of $30,000. And if you know anything about mobile homes, they decrease in value pretty rapidly. But they had equity because they had lost a home in a fire, and they had collected the insurance proceeds and then purchased this mobile home as a replacement to building back their home. The taxpayers were elderly. They were in failing health, both of the taxpayers. Taxpayers' only income was Social Security, and they were denied a home equity loan from the bank due to limited cash flow. So they wanted the resolution of this tax liability. And they weren't going to have a problem with future filing compliance because their only income was Social Security. Well, at the collection due process hearing, the appeals officer required $24,000 to settle. Basically, I think it was the what we call quick sale value of the equity. I think they discounted it by 20%, but they were requiring about $24,000 to settle. Taxpayers didn't have $24,000 to settle. But the IRS was content because that appeals officer issued a notice of determination holding the taxpayers qualified for currently not collectible status. And left it at that. Well, a lot of taxpayers, and then this goes back to the question that was asked earlier, might be satisfied with currently not collectible. But one of the taxpayers in this disjoint taxpayer situation had a lot of mental health issues and could not even fathom still having a tax liability, even if the IRS wasn't going to collect it due to the currently not collectible placement. And so they appealed to the tax court. And with this appeal to the tax court, and we got involved in this case at the tax court, and we took it on. We actually were able to investigate and find that the appeals officer had never even looked at whether the tax assessment procedures had even been followed when the taxpayers contested it, and they hadn't verified all laws and administrative procedures had been properly followed. So we were able to convince the court, I think it's Judge Dawson in this particular case, that the IRS didn't do that, and it was past the assessment statute of limitations, so the $50,000 tax liability went away. So, which was even better than the offer and compromise the taxpayers was pursuing. But looking back at that, if I'm looking at it from the government's perspective, I mean, the taxpayers were offering $5,000, and that was turned down. And they had no other assets. Their income was limited, Social Security. They didn't have the ability to acquire future assets, but yet the government turned down a $5,000 offer and compromise from them. So, I mean, it ended up what happening for the government is they didn't collect anything on the case, which is because they got a low-income taxpayer clinic involved, and we looked at all these other issues in the statute. So, you know, I look at that and think, well, the IRS really is failing to capitalize on these IRS collection alternatives. And I look back too and look at this agency action, and I'm thinking they didn't consider the relevant factors. They didn't really listen to the taxpayer. There was an erroneous assessment of facts. There was kind of an erroneous view of the law, and they weren't using their discretion really in this case. So this is kind of an example, I think, in this conversation about IRS collection and collection due process and abuse of discretion. These are the things we're seeing out in the field. We see this sometimes too with installment agreements. Not a lot of our clients qualify for installment agreements or could afford them, but their experiences sometimes present hurdles to the government setting up a payment plan. I have taxpayers who don't qualify for an installment agreement, a full pay installment agreement. But getting the government to look at a partial pay installment agreement and collect some revenue is very, very difficult. We do produce financial statements and we get that and we make that happen. But I can tell you, pro se taxpayers don't know about partial pay installment agreements, and they don't know how to present that information. So a lot of taxpayers, when they come to us, they've tried to get an installment agreement. These are the taxpayers that can't afford to pay a little bit, and they want to pay a little bit and try to resolve this, even if they ain't going to pay the tax debt off. But they get denied these partial pay installment agreements because it's not even being brought up by the IRS, whether collection function or whether it's the appeals function, as a possible resolution, which would help the government collect more revenues. So this, to me, is another example of agency action. It's not demonstrating reasoned decision-making and trying to collect revenue and getting to what I would think is the right result here in this case. But also, one thing I wanted to mention, and it feeds on what Les said, the IRS in the collection due process statute, they are aware of the language about the balancing test that we've discussed, about the IRS being charged with the balancing the need for efficient collection of taxes with the legitimate concern of the taxpayer that it's no more intrusive than necessary. So this language, like Les indicated and suspected, is in all these notice of determinations. But when you read the facts of the case, and especially if it's your case and you're looking at all the issues that you raised, and maybe those issues and facts are cited in the notice of determination, but there's no connection between the two. There's no analysis where the IRS went through and applied those arguments that were raised to this test. But yet they stamp this almost like a template at the bottom of the notice of determinations. And so it's really frustrating because I understand the reason. It's not that the IRS is acting intentionally in bad faith, but you have appeals officers who are constantly talking, and settlement officers are constantly talking about increasing caseloads. And so they're trying to get through as many cases as possible. And when you do this, though, it makes it harder and less of an incentive to take the time to look at the case facts, and they take the time to go through this analysis. And is this determination really balancing the efficient collection of taxes with the concern that it be no more legit? I mean, it be no more with legitimate concern of the taxpayer to be no more intrusive than necessary. And you can see that it's not. And because of this, through a clinic perspective, we're taking a lot more cases to the tax court and getting the tax court involved and getting the court to say, hey, this is what needs to happen. This is what the statute says should happen. So those are a few examples. I mean, it just always baffles me when we have taxpayers who or some of, and it's not the norm for us, but taxpayers that can make more than $1,000 settlement offer, and it gets rejected from the IRS because they may have, looking at their assets, there may be a valuation of more than 1,000, but they can't tap into that. They don't have the cash flow to make a bank loan payment. The bank denies them the loan. And so it's real frustrating. So the government will say, yeah, but they qualify for currently not collectible, and we'll turn around and not collect anything on this case. And as we talked about earlier, which was such a great question that was raised as to why look at an offer versus currently not collectible, there's so many benefits to the taxpayer and even to the government with future compliance. So doing these offers, that's not really benefiting anybody at the table when you do that. So it's worth the time to look at those other factors. And another example that comes to mind is when we present offers in compromise, and the Internal Revenue Manual lays out situations when the government can, for example, vary above standard allowances, whether it be local standard allowances or regional for transportation, local for housing, or your national standard allowances. The IRM, Internal Revenue Manual, is pretty clear. You can go beyond those standards when it's necessary for the production of income for the taxpayer's job, or when it's necessary for the taxpayer's health or welfare. But my experience, and I just had this case in the last couple of weeks with the offer and compromise unit, is that they may agree that you're presenting those facts, but they feel like have to make a determination to reject it, and that we would have to take that up with appeals, because that's something they see appeals utilizing that discretion. They don't really feel like they have that discretion. And I've seen that kind of go back and forth over the years, about 23 years of doing offers, where the offer examiners did make that call, and we didn't have to file appeals, which was great for everybody involved because that's less use of resources. But going back to now, where they're saying we can't use discretion, we just have to look at standard allowances, even though the IRM says we can utilize this discretion, and only appeals can utilize that discretion. And so, and hopefully appeals does, or then we're seeking judicial review when they don't. So that's another example. One last thing I really want to kind of focus on here is that when you are depriving maybe a taxpayer of an offer in compromise or a collection alternative, or something, a resolution of so maybe it's an installment agreement of getting the tax liability paid in full. If that taxpayer qualifies for the earned income tax credit, obviously they're going to lose future refunds through refund offsets, unless you're able to get TAS, Taxpayer Advocate Service, to particularly help on that case that you're working through an offset bypass refund. They're not going to see these low-income taxpayers who have qualifying children, or maybe even taxpayers who qualify for the EITC without qualifying children. They're not going to see this government subsidy that Congress intended for them to receive and help them while they're struggling to pay for health insurance and all the other necessary living expenses that the IRS acknowledges. They're not going to receive this benefit that Congress intended for them to have each year for their children. So it's somewhat frustrating when I think the IRS sometimes doesn't look at these cases through the lens of the taxpayer, when it would also benefit the government to do so in collecting more revenue. And so again, I would say IRS failure to capitalize sometimes on IRS collection alternatives is a real concern. Maybe IRS not utilizing the discretion that Les talked about in CDP that they have. Failure to expedite. One of the big things I see too is just failure to expedite some of these controversy resolutions. I'm sure if we ask Jeff, he could pull up, but just based on the information he's already given us today, the longer you delay resolution, it results in paralysis to taxpayers, non-compliance. That's some of the statistics you mentioned to support that. Non-compliance with future filing responsibilities and payments. And it's because the taxpayers they lose, when they get frustrated with the system and it takes so long. And I looked at the average life cycle of our tax court cases, and I looked at the life cycle of our offer cases, and they can take over 2 years. And the longer it takes to resolve something, the less interested they get, and the less determined they are to kind of avoid future problems, because they start feeling a little bit apathetic. And so I think the agencies really need to consider relevant factors for low-income taxpayers and demonstrate reasoned decision-making to avoid some of the, resolutions that are going on right now that are not benefiting either party, taxpayer or the IRS. So those are a couple of my examples, and we've had some cases. I know the Vinatieri case, that's been out for a while, but that was an example in a collection due process hearing where the IRS appeals officer said, you haven't filed tax returns. So even though we acknowledge that you're in economic hardship, we're going to sustain the levy, and which is a low income taxpayer victim of abuse. And the interesting thing, the tax returns, and once we got involved in this case, the unfiled tax returns were refunds. So it wasn't that the IRS was losing out on anything, but it forced the court to get involved, and it forced the court to make a decision and say, hey, you can't go forward with a levy action if somebody's in economic hardship. They don't have to demonstrate compliance. And it led to, I think, an edit of that Internal Revenue Manual provision and case law that helps support taxpayers. So I think,
and there, to that point, I mean, I think Vinatieri is a really good example of Les's points about this sort of the systemic reform nature of collection due process, because when the Vinatieri decision came down, the judge called one of my attorney advisors who used to be a tax court clerk and said, you need to get Nina to look at this case. And when we looked at the case, it was like, okay, how many IRMs say that the taxpayer has to file all their returns in order to get into get a release of levy for economic hardship? And it was all over the IRM. And we got counsel involved. We pulled a team together and we corrected all the IRMs. And I personally did training for appeal settlement officers. Now, I do have to say that any tax employee will tell you that they regularly get these cases where they have to send over the Vinatieri opinion to the settlement officer still today to say, read it, you cannot do this, or they have to send it over to, collection to do this. So it takes a while, but that case alone had significant impact. And there would have been, prior to 1998, there would have been no judicial review. I would have been, just, tilting at windmills like I often do, but, to get that changed. I want to go for a second to Jeff because I'm conscious on time. And one of the things about offers and compromise that Jeff, in that study that you all did, on offers, and I know 1 year it was looking at individual offers and 1 year we looked at business offers, but part of what we looked at, and this goes to Mary's point about leaving money on the table, was we looked at the rejected or kind of withdrawn offers to see what taxpayers actually offered initially. And what the IRS determined was the reasonable collection potential under their standards. This goes to Mary's point about the mobile home. And then what the IRS actually collected after it rejected or returned the offer. So I know I don't want to put you on the spot about the numbers, but maybe you could talk generally about what you saw there.
No, I was actually just looking it up while Mary was talking about it. So in about 40% of the cases, the IRS collected less than what the taxpayer offered. So, I mean, some of the offers, they probably really were not viable offers. But one of our recommendations in the study was that the IRS needed to look at that issue and decide, try to better understand what those cases were where they were really making the wrong decision on. Because it is a sizable portion. I mean, 40% is a decent amount that the IRS has never been able to recoup as much as the taxpayer offered.
Yeah, that to me is just like your eyes are bigger than what's the reality. You think you can collect something, this whole definition of reasonable collection potential, a lot of it goes to assets that really aren't available to the taxpayer, that the IRS itself cannot touch, or that it's overvaluing. And we also saw that in the businesses because the businesses went out of business. And so where are you? You do have to do responsible person, but you may not have done that timely enough. I want to take the last 10 minutes to just ask each of you, since this is about transforming tax administration, and Jeff, I'll let you have the last word on this, so think about it. What would you want the IRS to do going forward? And to do better in the collection arena. And I highlighted 2 of the strategic operating plan initiatives about, basically trying to, offer proactive debt resolution and use data and analysis to do timely and tailored collection contacts. And of course, that goes with the Taxpayer Bill of Rights, to a fair and just tax system, that the IRS will consider the facts and circumstances of the taxpayer in its actions. So Les, let me turn to you, and then I'll go to Mary, and we'll close with Jeff.
Yeah, I'll talk about 2 things. And, one is building on a theme I previously mentioned, and actually connects as well to Jeff's talk about the study about communications with incentivizing taxpayers to maybe file an offer. And the second goes back to some of the CDP points I made. The first is I would like to see a really designed commitment to experimenting with communication in the collection process, to use the opportunity to using controlled groups and test groups, and using different kinds of communication to see whether and to what extent different kinds of communication might promote a taxpayer's understanding of and ability to kind of navigate a pretty dense process right now. And I think that requires kind of a commitment to thinking about whether it be a collection due process notice or communication in the collection stream, just to really take a step back and not only think about maximizing revenues, because as we've talked about, there are situations when really a taxpayer, due to their circumstances, is not in a position to pay a liability due to existing expenses or hardships that Congress has recognized might take precedence over payment of a short-term payment of a tax liability. So that would be one a change in culture, a change in commitment to that process. The other, goes to some of the cases that I've talked about and that Mary mentioned as well, and the culture of appeals in CDP. I think when you read some of the opinions where the court has actually remanded, including the Whitaker case, which just from a few weeks ago, you see the court kind of looking at appeals and saying, appeals at times just kind of has blinders on it and is not kind of taking a holistic approach to the taxpayer's circumstances. And what the court is doing there is saying, hey, go back and consider the circumstances, consider the possibility that the taxpayer's house actually has a value different from what Zillow might say. Ask the questions, especially for taxpayers who are unrepresented, right? When a taxpayer has the benefit of Mary or others, they can make that taxpayer's circumstances pronounced. But there are so many more cases where taxpayers are on their own. And I think that kind of gets to the nature of the process. And again, maybe that's a training issue, it's a culture issue, but there is an opportunity to change the norm and change the way that appeals does its job in those cases.
Well, that really, thank you for that. And that really brings up something that always irked me, which is that here's appeals, and it's now called the Independent Office of Appeals. And we have a question in the chat that's asking me directly, where does appeals get its CDP personnel? And it's from collection. And that goes to my point about the IRM. Appeals has a CDP IRM, but when it's evaluating collection alternatives, it's relying on the IRS, small business self-employed IRM, or whatever particular procedure it's looking at. It's not giving an independent review as to whether the IRS's interpretation of what its powers are actually correct. And that is not the independent review. So it's like appeals is putting the hat on of collection personnel in looking at these pictures, which is, I think, as these situations, which as you said, have blinders on, or maybe it was Mary. So that, I think one of the things to do is to get them to basically give guidance on how they are really going to evaluate these collection alternatives independently. Mary.
Okay, well, I would, if I had to look at what would I want the IRS to do better in collection, I think, and it's kind of a theme of some of the things I was mentioning, is I would like for them to expedite some of this controversy dispute resolution. I just see so many of my clients getting paralysis from the time period it takes to get this resolution to that they don't comply anymore, and that they become apathetic. So I think if maybe it may take assignment or employing more IRS appeals officers and settlement officers, but these appeals cases, they need to expedite controversy resolution through these appeals cases. It's just something that seems to be getting worse instead of better. And I think that would help encourage taxpayer compliance. And because the taxpayer, they do have this paralysis, because I feel like if they've not been treated fairly, which is, looking at the Taxpayer Bill of Rights, and you can see that some of the arguments they make fit squarely within the Taxpayer Bill of Rights. But if those things haven't been done, and there's not a conversation that's taken place about their case, or they're having to wait 2 years to have that conversation, then why should they fulfill their own responsibilities and preparing and filing their returns? And so that is one thing I would really like to see IRS, especially IRS appeals function, look at, is expediting this controversy dispute resolution by employing more settlement officers or appeals officers. But probably the biggest thing that I think that I would want the IRS to do, or put on my wish list, was require them, and this dovetails exactly what was said by Les earlier, but to show that they've actually more trainings to explain they have some discretion in certain things. There's IRMs that support the discretion, so they're not going off on left field and making these determinations simply even on the case facts. I've had IRS settlement officers tell me, well, I can't do that because that's not how we look at it. And I said, well, yeah, you even have an IRM that allows you to do that. Oh, we do. And so, I mean, I just don't feel like there's been enough training to explain the discretion they have and the authority that they already have at their disposal. But more importantly, I think what I would like to see them do is to come up with some forms. I know the Innocent Spouse Relief Unit in analyzing innocent spouse cases used to have a form when they had to balance all the factors for innocent spouse relief, because every time I would get a determination from appeals, unless maybe it's in the court and I get the appeals case memo from Discovery, I would see where they went through and they've actually analyzed the facts and they've come up with their determination. Whether I agree with them or not was another issue, but they did that. And I don't see that happening in a CDP case. So I don't have those. I think if IRS appeals, like especially for the collection due process hearings, to make sure that balancing test analysis is really taking place and it's not boilerplate, it's not just stamped at the end of that notice of determination. Let me see some forms where you've addressed every fact the taxpayers brought up, and why. Tell me why that you didn't think, or why you think that you should still proceed with collection action. If you're going after a taxpayer, and this has been a number of our cases, if you're going after a taxpayer and say you're sustaining a lien action, that taxpayer has no assets, they're disabled, their only income is Social Security, disability, or SSI, they have no ability to purchase future assets. Why are you sustaining the lien action? I mean, we mentioned this earlier. How is that balanced and efficient collection of taxes with the requirement that it be no more intrusive than necessary? It's intrusive to the taxpayer to have a lien, but the IRS lien is accomplishing nothing. And so what that does accomplish for the taxpayers, it makes them more apathetic and more kind of belligerent and determined not to comply when they feel like the IRS is not even doing what even the law says that they should do. So I think to kind of, I know the appeals officers, settlement officers are overwhelmed, but to have forms, to have the IRS come up with forms that make them go through and list all the facts that are raised and the issues and address those, and let me see some analysis and connection before I see just a stamp, that we accomplished this balancing test when you look at the facts and there's nothing addressing why they didn't do that. So that would be on my wish list.
That's great, Mary. So we've got a comment here that is, get rid of the opening statement by ACS, what can you pay? Taxpayers believe that hardship doesn't even exist. Taxpayers agree to pay the installment that is completely unreasonable, unconscionable, because they believe there is no other option except the misconceived belief of jail. And I think that also goes to a comment that came to me about, why don't we focus on the frontline people too, or the OIC people, not just appeals officers? And I think that goes to the point, to the communication point. How are you framing these issues? And it also goes back to my economic hardship indicator, which is that if you applied the algorithm you would, for a lot of people, be able to identify that they may be at risk of economic hardship, meaning they can't afford, to pay a certain, an amount and still pay their basic living expenses using the IRS's own formula. And so having that indicator on the account would prompt a whole bunch of actions. For example, the ACS person not starting the conversation with that opening statement, but a very different one. And that's using technology to really bring about meaningful taxpayer Bill of Rights implementation. So Jeff, why don't you close us with what you would like to see?
Okay, so I have three things initially that I would like to see. One is really simple. It's getting the IRS getting to delinquency sooner so that taxpayers aren't buried under a load of debt that they're going to have a really difficult time from getting out from under, and so that they can cure that non-compliance for the future. The second thing, and I think this touches on an issue from both Les and Mary, I would like to see the IRS have more conversations with taxpayers, and not just conversations, but being willing to exercise good, sound judgment to make decisions on their own. Because Mary is correct, there is room in the IRS for deviation when it's warranted, but it's been my experience that the IRS is often unwilling to do that. We had the allowable expense study, I think in 2018, which showed that we didn't oftentimes make the right decision based on the circumstances. And I think that goes to the CDP process as well, where even when good facts are presented, sometimes the appeals officer is unwilling to deviate from the IRS allowable expense standards. And then thirdly, I would like to see more tailored collection treatments so that we don't treat all taxpayers exactly the same way. I think we do now, and I think we could be more efficient if we treated them somewhat differently. But overall, I guess that conversation, that personal judgment. And I think the IRS has resource concerns that, if we take more time, but I'm not convinced that that's not going to save time in the long run.
Yeah. Yeah, I think that's really important. And I know we've tried to measure downstream consequences and time spent on issues. For example, the installment agreements that are then defaulted and you have to address them. You're putting taxpayers into installment agreements through streamline, just divide by 7 years or whatever's left on the statute. And then they agree to it because they just want the IRS to go away, and then they default on it. And then you've got a whole set of issues with more expensive personnel that you're dealing with downstream. So this has been a great program. And I think I forgot to mention at the beginning that Jeff started his career with the IRS as a revenue officer. So he does bring some frontline experience in dealing with taxpayers on these issues. But I think you can see that we would all love to have a revenue officer like Jeff if we could have one. So thank you all for being here with us. And we will see you in a couple days at our next tax chat dealing with the issues facing international taxpayers, newcomers to the United States, taxpayers who need ITINs and the ITIN processing system. So thank you very much, and we'll see you soon. Bye. And thank you to our wonderful guests. Thank you.